Jennifer Springer from Passalacqua and Associates. We represent people who have been charged with a crime or have been seriously injured that don't deserve to have their lives ruined as a result. Today, I'd like to take the time to talk to you about DMV refusal hearings, how they work, and how they can affect your driving privileges if you refuse to consent to a breath, blood, or urine sample during a DWI investigation. First, it's important to understand that a DMV refusal hearing happens if you're placed under arrest under the suspicion of driving while intoxicated in New York State and then refuse to provide a breath sample, a blood sample, or a urine sample to be tested to determine what your specific blood alcohol content was. This hearing is very unique. It's not part of the criminal court system, and it's held in front of what is called an administrative law judge. The second thing you need to understand that as a result of your refusal, you may be subject to a 1-year administrative suspension of your driving privileges. I say may because all too often we hear of officers threatening our clients, attempting to convince them that a refusal automatically results in a 1-year suspension of their license. This isn't true. What is true is that you will be given a DMV refusal hearing. And if you prevail at that hearing, there will be no suspension of your license. However, if you do lose at the hearing, then your license will be suspended for 1 administrative DMV year. The third thing to know is that upon arraignment, if you're charged with a DWI and have refused to provide any chemical test example, your license will be suspended by the judge. It is important to remember that this is a very particular type of suspension. It can only last for 15 days or until the time of a DMV hearing, whichever happens first. This means that if you have no hearing by the 15th day after your arraignment, the full normal driving privileges you have will be reinstated on day 16. These driving privileges will remain in effect until the conclusion and decision of the administrative law judge. The fourth tip I want to share with you today is what to expect at that DMV hearing. At the hearing, the officers that place you under arrest will be required to testify under oath as to whether or not they performed their job properly. What this means is that they will have to establish that they administered any and all standard field sobriety tests properly and in the standardized fashion. They will also have to establish that they gave you the proper DMV refusal warnings and that you properly refused them at least 2 times. You will also have the chance to testify on your own behalf if your attorney believes it to be in your best interest. Finally, your attorney will have the ability to cross-examine these officers and try to establish the fact that any or all of these procedures were done incorrectly. So, if you or a loved one have been charged with a DWI and have been found to refuse the breath test, provide a blood or urine sample, or have been deemed to refuse because they claim you gave an insufficient breath test sample, contact the attorneys at Passalacqua and Associates immediately. We have extensive experience in handling DMV refusal hearings and have a very successful track record in prevailing on behalf of our clients. While every case is different, we can assure you that the attorneys at Passalacqua and Associates will do all we can to protect your license and your reputation if you're charged with a DWI. So give us a call today for a free evaluation of your case. 315-500-6425.